Hi, my name is George Saldana, and I'm going to go over Texas Rules and Civil Procedure Rule number 13. I'm not an attorney, I'm just a parent who knows how to read and comprehend. Now, this video is dedicated to Harris County Board Certified Attorney Carolyn Robertson, and let me tell you why. It was because of Carolyn Robertson's mistakes that motivated me to read Rule 13. Rule 13 is the effects of signing pleadings, motions, and other papers, semicolon, slash sanctions. The signatures of attorneys or parties constitute a certificate by them that they have read the pleading, motions, or other paper, and that to the best of their knowledge, information, and belief formed after a reasonable inquiry, the instrument is not groundless and brought in bad faith or groundless and brought for the purpose of harassment. Attorneys or parties who shall bring a fictitious suit as an experiment to get an opinion of the court, or shall file a fictitious pleading in a cause for such a purpose, or shall make a statement in a pleading which they know to be groundless and false for the purpose of securing a delay of the trial of the cause, shall be held guilty of contempt. If a pleading, motion, or other paper is signed in violation of this rule, the court, upon motion or upon its own initiative, which means the judge can initiate it, after notice and hearing, shall impose appropriate sanctions available under Rule 215/2B upon the person who signed it, a represented party, or both. Court shall presume that pleadings, motions, and other papers filed in good faith. No sanctions under this rule may be imposed except for good cause, the particulars of which must be stated in the sanction order. Groundless for the purpose of this rule means no basis in law or fact and not warranted by good faith argument for the extension, modification, or reversal of existing law. A general denial does not constitute a violation of this rule. The amount requested for damage does not constitute a violation of this rule. So again, in closing, I have to thank Carolyn Robertson for this video because Carolyn Robertson was the one who made me look for Rule 13. And I say that because, again, the wrong cause number, the wrong court, the wrong county that she was litigating in. I've never litigated in Fort Bend. I believe that we should hold attorneys to the highest of standards. Ignorance of the law is not an excuse. And if these attorneys are filing motions and pleadings without reading them, or their paralegal is writing these motions and pleadings, that it's important that these lawyers look over that, because at the end of the day, their pleadings and their motions are taking away from us, the pro se litigant or the opposing counsel on the other side. Carolyn Robertson filed motions and pleadings not only that were incorrect fundamentally, but she filed them to get a second and a third bite of the apple. When she put her signature, she knew what she was doing. When she filed a motion for genetic testing, she knew that that motion was brought to harass me because the state has already adjudicated me as the parent of Christopher Saldana 8 years ago. So her bringing a motion to check genetic testing to see if I'm Christopher's father, that was definitely a motion that I should consider filing sanctions on. Let me know what you think in the comments below.